Welcome to the Mediate.com video series, The Mediator's Views from the Eye of the Storm. I'm your host, Robert Benjamin. We are pleased to present to you significant contributors to the field of negotiation, mediation, and conflict management, the practitioners, teachers, and thinkers who have and continue to shape this emerging field. With me today is Arthur Pearlstein. Arthur, welcome.
Thank you.
Arthur, a graduate of Haverford College and thereafter Harvard University in 1981, and one of the first to take, taking one of the first course offered by Frank Sander on alternative dispute resolution, given at Harvard in 1978.
Yes.
As an incoming first-year student.
Yes.
And a recipient of a master's degree from the Pepperdine Strauss Institute for Dispute Resolution, the Master of Laws degree in 2000?
Yes, but not a Master of Laws. It was called a Master's of Dispute Resolution.
Okay.
And I was offered the opportunity to turn it into an LLM when they later offered that, and I said, no thanks.
Okay. All right. All right. So you were content with the Master's in Dispute Resolution?
And I actually preferred it.
Good. Good. You are from originally Northern Virginia, and after having graduated from law school, having taken one of the earliest courses in dispute resolution from perhaps the person most recognized for the legal education of dispute resolution, Frank Sander, you worked for two major law firms in the D.C. area. Mm-hmm. Practicing law for approximately 4 or 5 years in the employment litigation area. Mm-hmm. And even though maintaining an interest in mediation, tried to steer clients towards mediation. I'm going to want to hear your thoughts about that. It sounds like you had some but only limited success.
That's right.
In doing that.
Yes.
I want to hear about that and see what your thoughts are about it. And then proceeded to form your own firm, again continuing in the employment litigation field in the D.C. area, Virginia, Maryland area. And then, because of where you were living, with lots of folks from Central America around, got drawn into and enthused with the idea of teaching English as a second language.
That's right.
Area.
Yep. Right. I did it as a volunteer at first. Yeah.
But just became so interested in that that you actually left your practice, negotiated an arrangement, and really began to focus on that. And then for the next close to 3 years, in fact, traveled abroad to Turkey and Malaysia, and as part of learning how to and teaching, you also began teaching negotiation elsewhere in the world.
That's correct.
All right. A very interesting prospect, and really begins to develop the whole international connection of what we're doing here, and letting us know that this is not the only country where the interest in negotiation and mediation
That's right.
has been maintained. Came back and taught an institute for immigrants and diplomats, and only in the year roughly 2000-2001, after your master's in dispute resolution from Pepperdine, joined FMCS as a general counsel.
That's right. General counsel and then director of the Alternative Dispute Resolution and International Program at FMCS.
Okay. And that also, very, very interesting, and a piece in the field, benchmark in the field, where FMCS then starts to move into alternative dispute resolution procedures and looking at things perhaps in a different way than they have for many years. You are now the first director of the newly founded Werner Institute for Dispute Resolution at the Creighton University School of Law.
That's right. It's actually called the Werner Institute for Negotiation and Dispute Resolution.
Negotiation and
Yes.
Dispute Resolution.
Yes.
Okay, good. And I want to pick up on that. Again, it's part of this, of what appears to be a trend of law schools and other universities beginning to formally focus on the teaching of negotiation and dispute resolution. You have received awards from the FMCS for your distinguished work and service, and no small feat, Best Student Award from Pepperdine. You know, they have many exceptional students. To have received that award then is clearly an honor. And the author of a number of articles, one most recent, an article co-authored with Bernie Mayer and Peter Robinson with regard to dispute resolution design, published in the Harvard Negotiation Journal.
The Harvard Negotiation Law Review.
Excuse me, Law Review.
Yeah.
All right. Let's start back. In 1981, you took one course in dispute resolution, or a survey course, I assume, from Frank Sander.
81, I graduated from law school. It was the end of the 70s when, in my first year at law school, but I took the course from Frank Sander.
Yeah, but prior to that time, I assume, had very little awareness of the specific course of study of negotiation and other forms of dispute management, resolution. What captured your imagination, do you recall?
Basically, it just seemed so different from everything else I was learning at law school. Everything else was sort of the adversarial system and figuring out how to beat and outmaneuver the other side. The course on IDR was really something different, and I found it kind of refreshing and very interesting.
So, kind of kept it in mind.
Yes.
And throughout, even as you went out and began to practice and do what you were trained to do at Harvard, which is practice law in a fairly traditional way, in a traditional context. And yet you indicated that you tried to steer clients to look at things in different ways, but encountered a certain measure of resistance.
Yes.
Tell me about that.
Well, it just, more often than not, either the client or opposing counsel really was against it because it, as I read it, they felt it was a sign of weakness to agree to participate in a negotiation process or a mediation process, certainly to participate in one relatively early in the stages of litigation, rather than pretty much wait till the courthouse steps.
Now,
it was a hard sell.
Have you? What is your sense? Do you think that things have changed significantly since the early '80s when you were practicing law?
I think things have changed significantly in the sense that lots more people are aware of the options. Lots more people have some training, or at least took one course in law school in it. But I still think it is a problem. I think that this notion of I don't want to be the first to suggest it, or I don't want to appear weak, still is very commonplace among many lawyers and clients.
What do you attribute it to? What's that in our culture, in the water, or whatever, that encourages a resistance to?
I attribute it to the way the judicial system essentially has emerged in this country as largely a monolithic structure, that things are done a certain way. You're taught to do things in a certain way in law school. And the incentive structure in that system in particular is in doing things a certain way, which is very adversarial.
Now, as you take the helm of the Werner Institute, what will you do different? In other words, you'll be teaching law students, I assume, among others.
And others actually are. I mean, I am now teaching in the law school, but our interdisciplinary program, our master's degree program, starts in the fall, and we expect to be teaching students from all walks, all disciplines, and certainly not limited to to law students. We'll be emphasizing a number of different things. My general philosophy is that more and more the whole field of dispute resolution will become, or should become, in most instances, a private matter, a privately ordered matter, as opposed to a court-run, a judicial system-run situation.
But the vast majority of cases seem to come out of the litigation frame. I mean, here we are at the American Bar Association's section on dispute resolution, and I dare say that most of the people who practice are looking for cases to be referred to them from the courts that are in some phase of active litigation, are they not?
I certainly think that now there's a very high percentage, perhaps a majority, but I believe and certainly hope and will work for that to change over the course of time. I think that more and more, particularly in organizations, in the international sector, in the internet, and in other areas, courts are becoming, or should become, more and more irrelevant.
Irrelevant?
Yes.
Well, tell me a little bit more about that. I mean, you really do see a time when people will be largely settling disputes outside of the courts?
Sometimes it's difficult to distinguish between my hope and philosophy and my expectations, but I do think that there are in certain areas that will definitely be the case. In the international sphere, less and less is done in court. Nobody wants to, in international business transactions of all kinds, nobody wants to be in someone else's home court. More and more is being done through privately developed dispute resolution.
So part of this the shift will happen as a result of globalization.
That's a large part of it, yes.
As Thomas Friedman says, the flattening of the world.
Yes, the world is flat. Another phenomenon is the growth of the internet. The internet moves too quickly, and it's it also is international, but it also is hard to pin down. And all of those factors make it very, very difficult for the courts to insert themselves and create much incentive for people to resolve their disputes there through other means besides going to court. And those are two big examples, but I think more and more in certain industries, in certain kinds of organizations, more and more corporations are creating their own dispute resolution systems to try to keep things out of court. And more and more, I think, sectors of the economy, people are learning that resolving things through court is very expensive, time-consuming, and wasteful.
But even that's always been the case. I mean, and those are good, certainly rational reasons for why one would think people would mediate or negotiate, and yet they still don't.
Well, I think in more and more walks of life they are. In some, it's more of a slower process than in others. But in some areas, it's been that way for a long, long time. For example, in the labor management sector, for many decades, the exception has been court, and the rule has been arbitration and mediation to resolve disputes. And I think increasingly in industries and in certain walks of life, more and more people are learning that just from experience and just from more exposure to the alternatives, that there may be a better way. Now, a cautionary note that I have to that is the degree to which courts are inserting themselves in the whole process of alternative dispute resolution, and I think that's in some ways, although many people embrace that and applaud it, I think that there's a certain danger to that.
So what you see clearly in terms of what has drawn you in to this field, and I gather from your teaching experience and in terms of dealing with people that mediation offers the prospect of an immediate people talking to people and being able to manage their own conflicts and having a maximum level of self-determination and control.
Yes, although one thing that I caution about, I don't limit it to mediation. I think what's important, the important part is the self-determination part, which is parties working out for themselves how their conflicts will be resolved. Mediation allows for that, is one way of doing that.
Maybe that they'll be more effective negotiators. It may be that they'll do other procedures.
Maybe they'll create their own arbitration plan or their own stepped program, or use evaluation, early neutral evaluation, any number of possibilities.
And some increasing shift of awareness towards that. But then your concern is then, as you review things over the course of the last 25 years, is that as it's become more institutionalized, be careful of what you wish for, because this concept may be injured.
Yes. The example that I always give people as the real cautionary note is the whole the civil discovery process. Which was originally, the discovery process that we know now was originally sold and genuinely and sincerely by people who thought that they didn't use the term alternative dispute resolution, but they basically said this would be a way to get cases to settle very effectively and efficiently if we could just get the parties to exchange information in a very robust way very early on, and this would lead to rapid settlement, and it would create a much more humane system, et cetera, et cetera. What happened was it became, in effect, part of the game. Lawyers got their arms around the whole process of discovery and turned it into a series of gigantic hurdles. And now the discovery process is the tail that wags the dog in civil litigation. A very high percentage of the time and expense of civil litigation now is in the discovery process, which I think most lawyers would agree is not always about the genuine exchange of information and the genuine effort to resolve.
It's a quite interesting concept, because what it appears to be, if I'm hearing you correctly, is that this is a perfect example of unintended consequences.
Exactly right.
So that what we have is that the original design, I assume through the federal rules of evidence being a good example of that, let's let everything be discoverable, your term robust, and that if we do that, people will move to settlement, and then what in fact happens is almost exactly the opposite.
That's right.
And that discovery is the game to delay the process.
Exactly.
We're not done yet, Judge. We've got another 10 sets of depositions to do.
Exactly.
Okay. And so, but at some point, though, I mean, that's an interesting piece, because you very often hear that people are not ready to mediate because the discovery isn't done. Or alternatively, we don't want to allow mediation to be used as for discovery. You're taking advantage of us.
That's right, and what I see as, I mean, I think there needs to be research on this, but I see the various court annexed ADR programs as being used as another set of hurdles and delays by lawyers in much the same way in the long run. And again, I think this is changing. I mean, it's at first it was a new concept, and people were embracing it to the extent that they were in a very optimistic way. But I think now there's a danger that more and more lawyers, when it's court ordered and court run, they're seeing it as a necessary part of the process and another opportunity to wear down the opponents, just as the discovery process.
Just another strategic ploy.
Exactly right.
Draw things out.
Exactly right. And that's my biggest fear about the whole court, the whole multi-door courthouse, which is what, when I was in law school, I thought sounded like such a great idea from Frank Sander, and now I've actually come 180 degrees around and actually think it's not a good idea.
Well, I was just interviewing, talking with Kimberly Kovac, who has written a piece that encourages, she comes from Texas and was involved in their legislative scheme to have mandatory mediation, to expose lawyers to the prospects of how useful it can be. Upon finding that they were becoming more and too evaluative, has suggested in a recent article that there be good faith requirements. Would that solve the problem? To have a good faith requirement that says that if you're trying to use mediation merely for discovery or to draw the process out, that we will sanction you.
In my view, that just makes it worse. It just makes it worse and worse, because then it creates another level of litigation over the issue of, well, was there good faith? And then starting to take apart the mediation process. Just the same way that has happened in the discovery process. So much of motions practice now is not about what information is being exchanged, but it's about the discovery process itself. And it just compounds, I think, the expense and waste.
This is almost an Alice in Wonderland thing, almost more curiouser and curiouser. Using one rule to cure another rule's problems creates more problems.
Yes, as you said before, it's all about unintended consequences. And I think unintended consequences are triggered more than anything else by, in effect, a monolithic system that tries to say, okay, we're going to create rules for how to do everything, and then when this rule creates problems, then we're going to create a new rule to work out those problems, and it compounds itself.
But this doesn't appear to be just the province of the legal system, of a monolithic legal system. It seems to me that this notion of the rational rules is part of, it's in the water of our culture. The belief that we can rationally solve problems with rules. In other words, you in employment litigation certainly must know that if you have an employee handbook, you can tell how much conflict there is in an organization by how thick their employee handbook is. More and more rules.
On the contrary, I actually think there's almost no relationship between the size of an employee handbook and the amount of conflict.
Really?
Yeah. I think it depends more on the culture of the organization, which may or may not be correlated with the size of an employee handbook. But I do think that that at least our legal profession and our political class places way too much emphasis on what I sometimes call man-made rules, rather than the rule, what they call in the traditional jurisprudence customary law, the law that sort of evolves from customs and practice and traditions and the way people interact with one another. And so yes, I definitely think that the legal profession anyway has pushed too far.
But you think that the legal profession is rogue in terms of our culture? In other words, it's only the legal profession. We have a country that's a rule of law, and people seem to enjoy. I mean, isn't it our entire culture where we believe that if we, whether it be the FDA or whomever, that if we pass more rules and laws, that things will be safer, cleaner, and fairer?
I think you have to distinguish between a rule of law and a highly regulated society. I think there is a real difference.
What is that difference?
The concept of the rule of law is sort of general overarching principles, like the Constitution. The overregulated society is like the examples you were giving of FDA and so forth, and the examples we were talking about a moment ago when we're talking about creating intricate processes for handling civil disputes, and the more complicated it gets, the more rules you have to make, and so on. And that I think is where we've sort of gone wrong. And it's not, when I say the legal profession, I like to think in terms of sort of an overarching judicial monopoly of which lawyers are a part. I consider lawyers in effect, I like to use the term freelance bureaucrats, that lawyers don't necessarily work directly for the judiciary, but are in effect part of the judicial bureaucracy that ply their trade on a freelance basis.
But am I hearing correctly, though, that you lay a whole lot of the issue of what I would guess you'd term unnecessary conflicts at the feet of the legal profession and legal system? In other words, that the way it has functioned, and that it is different than the society at large.
Yeah, I would say unnecessary prolongation of conflicts, unnecessary processing of conflicts. Yes, I do. I do lay it at the feet of the judicial bureaucracy, of which I consider the legal profession to be a part.
So, in your model of mediation, negotiation, what role would you give to lawyers?
I think it depends. I think lawyers can have a very substantial role in that, to the extent that their training as far as the ability to reason, as far as the ability to marshal evidence and to understand argument and to understand certain kinds of issues. I think lawyers can have a very, very important role in representing clients in private systems of dispute resolution. I think lawyers that are appropriately trained and experienced can be very, very helpful in representing clients in mediation, in arbitration, in all kinds of dispute resolution programs. On the other hand, I don't think that it is something that should be limited to lawyers alone. It depends on the degree to which the issues really are entirely law-bound or are more matters that are issues of custom and tradition and reputation, which I think is very important in solving disputes.
Would you term yourself, as I've heard others call it, a recovering attorney? Recovering lawyer? In other words, distancing yourself from those procedures and processes?
In some ways, yes, but I think it's actually important to take on those procedures and processes and to really look at ways to, in effect, expand the private ordering of dispute resolution. And in that sense, I don't discount the roles that lawyers can play.
What appears to be the block of the furtherance of the private ordering of dispute management? In other words, there's nothing in legal legislation that obligates people to file a lawsuit. They could take every opportunity to resolve their differences prior to filing suit. Why don't they?
Well, there are several problems. I think chief among them is that the judicial system is basically all but a monopoly on the whole dispute resolution process. It is highly subsidized by our taxpayer dollars. It comes with the coercive power of the state. And so it gives a real incentive, that plus the whole way the legal guild is structured gives an enormous incentive to push things into the court system. And that's sort of the main force pushing in that direction. Some of the countervailing forces, as I mentioned before, certain economic phenomena in terms of the international sphere, the internet, and so forth, are starting to push in the other direction. But there are a lot of very, very entrenched interests that I think continue to push in terms of solving things in court.
What would be a good example of that, of an entrenched interest that you think has played a role in bringing matters into the legal system that otherwise might not need to?
Well, the whole interest, as lawyers are trained and incentivized in their profession, they at least I think most lawyers probably believe, and not necessarily wrongly, that they're most likely to get ahead as far as compensation by encouraging litigation, by taking conflict and bringing it to court. And I think that's an example. I think that's a salient example of it.
So this is a question of economics. If I get paid more, if I control this matter and it's in litigation, as opposed to if it is settled, I have a disincentive as an attorney of finding ways to help clients resolve conflict.
That example is, and I think economics plays a very, very important role in the whole field. Yeah.
It would seem, and I really don't want to mischaracterize it all, so you'll please correct me, but it would seem that you have a fairly dark then notion of legal practice. In other words, that the view of how lawyers are educated and encouraged to look at things is not as they might be as counselors or as reaching back 150 years to Abe Lincoln, which is, it's not smart to litigate. That lawyers largely don't have any kind of moral compass or other kind of notions of commitment to resolving conflict, and that their economic interests predominate.
I'm certainly not saying that lawyers don't have a moral compass any more or less than other human beings. I'm simply saying that lawyers are human beings, and like most human beings, they do want to do good things, but they also want to earn a living. As are what is developed in our legal system, I think, is a very top-down sort of authoritarian bureaucracy, the judicial bureaucracy, and lawyers are trained to be a part of that. They're trained that way, and they're incentivized that way. And I think that that doesn't mean that they don't have a moral compass, but it means that that's where their orientation generally is.
What would you say then to the lawyer that, or those who in this field who would say, a former judge who's working as a mediator or an attorney who's been involved in appropriate conduct disputes, whatever, employment cases, otherwise known as sexual harassment cases, or discrimination cases, or personal injury cases, of parties should not be trying to negotiate these things without that there ought to be a lawyer doing those kinds of mediations, that only a lawyer will understand the legal ramifications of what the parties might be doing, and that to head off their making errors.
I don't have any problem with lawyers giving advice and assisting in or conducting negotiations when there are laws and statutes that are implicated. I'm not suggesting that they shouldn't be involved. I'm talking about the processes for resolving those disputes. Need not be through a judicial monopoly. It should not be.
What would those on the other side say? In other words, if you had the argument against terming it a judicial monopoly, I could hear people being certainly cringing at that. The idea of asserting that there is a judicial monopoly.
Well, a lot of people would cringe. One commentator, I can't remember who, said that that judges are the last romantic figures in government. People still have this notion that the judiciary is somehow above everything else, and that they really are, as you almost suggested, on a higher moral plane. So yes, a lot of people would cringe, and a lot of people would argue that there are issues of fairness. That the only way we can ensure fairness in all these processes is to have the courts run the processes, and the only way to develop appropriate precedent is to have the courts run these processes.
And what would you say to that? In other words, if in fact we did have private ordering too much, then we might lose the whole process of stare decisis, or of precedent. I mean, that certainly was the early arguments.
That is the arguments, and my argument to that is actually, when you look throughout history, that historical experience suggests that these alternative processes for dispute resolution still developed, and in effect precedents still developed in systems of private ordering. So it is not necessary that the courts do that. And I'm not saying eliminate the courts, but I'm saying that the role of the courts should be much more limited, and that people that want to procure the services of courts to handle their garden variety civil disputes should have to pay for that, rather than have it be subsidized by the taxpayer.
So you would subsidize alternative dispute resolution, or you would withdraw some of the funding of the courts, or both?
One of the things that I would do is, if I could wave a magic wand, is at least incrementally, I would first of all impose a lot more penalties for frivolity in courts, which most courts, even with talk about it over the years, have been very reluctant to do. I would like to see more and more use of loser pays in litigation. I would like to see increased court costs that are more in line with the actual costs of that the courts incur in the process, and certainly there's a place for those who are indigent, who really cannot afford those, to be subsidized in that process. But for most people, for most litigants, they should have to pay for that. Just like they do for any other kind of service.
Well, but as I heard you, though, we need to be clear about the term of art. Frivolity is a term of art, legal term of art, as opposed to a popular understanding of being frivolous, although there's some overlap. The idea that somebody might file a motion or do a tactic purely for the purposes of delaying or dragging things out. But that raises an interesting question. When we were talking before about good faith, you're saying, well, you have more and more rules. There's more and more motions and more rules to fight about.
I'm not suggesting more rules. I'm suggesting more discretion in obvious cases. I mean, I've seen it a million times where parties are just very obviously using motions to delay or to run up the bill, or to harass the opposing party, and I think I think that's an area which I mean, there was a lot of talk about with Rule 11 sanctions and so forth over the years, but I think there hasn't been nearly enough done in that area. And as a more general proposition, I think that litigants in civil litigation, other than constitutional issues or important civil rights issues, should definitely have to pay the freight for the court process, just as they would for a private dispute resolution process. And if they had to do that's one way in which private dispute resolution providers would be able to compete more effectively with courts, and I think that would lead to a much more robust private dispute resolution industry than we have now. Because I do think that the courts are the largest competitor in the process. They are the elephant in the room. And it's very difficult to compete with them, and it's particularly difficult to compete with them when they're also offering these other so-called alternative dispute resolution services that are court annexed.
But here we are at the American Bar Association's conference, section on dispute resolution. it would seem on some level that there's a certain level of inconsistency with your presence that would tend to unwittingly or de facto support the bar associations from a foray into the dispute resolution field.
Well, I'm not a major contributor to the bar association, and I view my participation in these processes as a chance to let my voice be heard and sort of alternative voices be heard, which I think that is still something encouraged in our democratic society, and I think that there is at least the potential for people from within the bar, just as I have. If you'll forgive the expression, seen the light. I think that there's the potential for others, and not just the potential. I think others are seeing the light. And I think that one of the interesting things about this section on dispute resolution, it is still, I believe, the largest section of the ABA, and it is still, I believe, the only section of the ABA that widely accepts non-lawyers in its ranks, and so I think that those are potentially good signs. Although, again, with the cautionary notes that I have sounded, but I'm here. I view part of my role here as sounding precisely those cautionary notes.
What will be the focus of your program at the Werner Institute? In other words, will it be, do you have some hopes for it being different than other similarly named kinds of programs, and if so, how?
Yes, I'm hoping that we will be different and that we'll be able to distinguish ourselves. One of the things that we're doing in terms of our master's degree program is putting very much emphasis on areas of concentration. I feel increasingly in my experience that the marketplace is not very welcoming to ADR generalists. That notwithstanding what many of us in the field would like to have seen, that really what people are looking for is in the marketplaces people that know ADR but that also are specialized within a certain field. Within that, an application of ADR in certain substantive areas. So we're to begin with. You
would distinguish mediation in employment and organizational disputes from mediation in healthcare?
That is correct, and indeed we are offering in the first instance in our master's program 3 different areas of concentration. The first is organizational dispute resolution concentration. The second is healthcare conflict resolution, and the third is international conflict resolution. The program is structured so that students start out taking the more theoretical foundation courses and skills courses that have wide application, and then begin to narrow down and focus into a specific substantive area, and then do a capstone course, either thesis or a practicum in that area. So that's certainly one of the things that we're doing.
Why do you feel that that's so important? I mean, other than, I can certainly see the marketing of that. In other words, that many times consumers want to believe that that person is an expert in the particular substantive context. But other than that...
Well, but that is very important. My take on the field, the field of conflict resolution as a field in its own right has grown obviously very rapidly, and it's done some great things, but I think the focus has been very heavily on the supply side, which is to say creating mediators and conflict resolution specialists and so forth, and with less focus on the demand and what people are really ready to buy out there or to seek, and that is an area that I really want to focus on, is looking at more and more what is it that is being demanded out there. We don't want to be training students in negotiation and dispute resolution only to have them graduate and find that there's really no work for them, or that it's really slim pickings.
Well, but if I assume, what will be would you expect would be the relative age of the students that you have graduating from your program?
Very wide-ranging, from people straight out of college to mid-career professionals in their 50s, 60s, and even 70s.
Well, what will you say to a younger person who's graduated from your program with a master's degree? Be what they'll have from the Werner Institute from Creighton. Will they be able to find work in your mind?
Well, we're going to be working very hard with them to help them find that work, helping them leverage whatever background they do have as far as their undergraduate training, any other kinds of life experiences that they have had, and also their concentration while they're at Creighton, their substantive concentration within the field, and trying to line them up with externships and clinical work within the substantive area of dispute resolution. So that's what we are very much aiming to do.
And any other particular hallmarks of your program that you feel are going to be useful? You've been through some of the best programming in the country.
Yeah. Another hallmark of our program is the general interdisciplinary nature of it. We're housed in the law school, but the master's degree is awarded by is to be awarded by the graduate school. Students will be taking courses in the law school, courses designed by the Werner Institute, courses from the business school at Creighton, and from the Graduate School of Arts and Sciences. And students specializing in healthcare can be taking courses in the health sciences programs at Creighton. So that's another area. Related to that, one of the first things that I did when I got there was to establish a program on conflict resolution in healthcare, because I think Creighton is extremely well positioned to do that. I think it's one of the most important areas of conflict resolution, because there's so much conflict in healthcare in every sense, from patient-provider conflict to workplace conflict to bioethics issues, insurance issues. It's just very, very wide-ranging. And relatively speaking, not that much work has been done in that area.
Why do you see that as being?
That relatively little has been done? I think because there's a lot of people in the medical profession who don't like to think, particularly doctors, don't like to think that they have conflict. Rather, they tend to like to think that maybe there are some people that just aren't following orders correctly, or that there's some problem with their staff, rather than acknowledging that it's conflict. And so we're being cautious about that. We're focusing, we're calling it the program on collaboration and conflict resolution, and we're emphasizing a lot of what we're calling collaborative practice in healthcare.
Yes. How would you propose as a mediator, with your experience in that, or as a dispute management person, alter that thinking frame of that denial of conflict?
One of the things that we're trying to do is get to increase awareness and create programs within medical schools and health sciences programs in training of doctors and nurses and so forth. I think that the general coursework and training and so forth is part of it. Consciousness raising is part of it. And getting really good people involved is part of it. And we've got Deborah Girardi, who's chairing our program, who's just terrific. I mean, she's got a law degree and a nursing degree and a master's in public health, and is really one of the pioneers in the field. And so I think she's going to be able to do great stuff for us. And Creighton is, although it's a relatively small university, it has not only the law school in our program and undergraduate, but it has a medical school and a nursing school, a pharmacy school, and a dental school. So there's tremendous emphasis on it, on the health sciences there. And Omaha happens to be the smallest city in the country with 2 medical schools. So there's a lot of emphasis on health there, and so that's one of the areas that I think we can make a real
and lots of insurance companies.
Yes, and lots of insurance companies too. So we think we can build a real niche there among other areas. Dispute systems design, which is my own area of greatest interest, is another area that I'm really hoping that we can become specialized in and distinguish ourselves.
And I assume that gets into the work that you did at FMCS.
Yes, it does.
Building.
Yeah.
Tell me about that. The culture of FMCS traditionally was one that came out of the labor management era.
That's right.
And I think is still, isn't it? Is it not? Would you say that it is still, in many ways, controlled by that thinking frame, or not?
Yes, I think so. I think, and I think still the core mission of FMCS, although other missions have been added on, but the core mission has still been in labor management or union management conflict and mediating collective bargaining disputes over contract renewal and new contracts and so forth in it. But one of the areas in what I in coming aboard FMCS, one of the things I was hired for was to look at the concept of dispute systems design, which FMCS had not done much work in, and explore the notion that more and more of the conflict that takes place in the workplace is not union management conflict, it's individual employee conflict. The employees may be part of a union, but more and more what's happening is they're bypassing the union and they're going to their lawyer. And more of it is taking place in that way. And so what FMCS was very interested in looking at was what can we do, what can the agency do in that area? And I took that job in part because I was going to be given the chance to head up that program of looking at the state-of-the-art in dispute systems design and trying to see what could FMCS do.
So not letting the issue get framed as a labor versus management issue because that's the only system available, not letting it get framed as a legal matter in litigation because that's the only thing available. How would you insinuate in an alternative design that allows it to be dealt with as you think it is, a personal, relational issue?
That's right, and with the added angle that dispute systems design in the workplace has taken off over the last, decade or so in a number of corporations in the non-unionized setting. But in the unionized setting, the only real dispute systems have been collective bargaining contracts that provide for arbitration, but there are more and more disputes that are taking place outside of the parameters of the collective bargaining contracts.
Waiting to negotiate when you're do it in the context of a collective bargaining agreement isn't particularly satisfying
to many individuals these days with a wide range of disputes, and in many cases it's creating problems for unions. Sometimes it will pit union members against each other. Sometimes it creates work for unions that they're not really prepared for design.
Doesn't that, how have you found unions in response to that idea? It would seem that the unions also have their own form of monopoly, and that anything that circumvents the union representation would seem to undermine or diminish the place of the unions and their authority.
Well, that's exactly right, and that's why we had to be very careful about it. We spent a lot of time talking to people on both sides, people on the management side and people on the union side. We did run into a lot of reactive devaluation. We had a lot of it. We would go to unions and talk about it. They would raise concerns, and then we would tell them why it could be good for them, because what we were talking about is having the unions very much involved in the design process. And then when they would say, boy, that sounds like a great idea, they would say, management will never buy that. And we said, well, we think we can. And as soon as they understood that management might like it, they'd say, gee, there must be something wrong with it. And the same, vice versa, the other, with management.
So those age-old distrusts would rear their ugly heads.
Yes. But what we found, as we began to look at it, that in many settings, they were interested in taking a serious look at it. because the program that we developed, the set of protocols that we developed, very much had the unions involved from the get-go in the design process, and they didn't have to agree to anything that they felt would threaten their position as sort of advocates for their members.
So, pulling this together, you've been in the field now for a good 25 years. What do you see for the next 25? What's your future look like? What do you see as being the future of the field?
Well, I am very optimistic that some of the principles that I've talked about, the increased private order in the field, are going to take hold. I think in many areas, as I mentioned before, it's inevitable. I think more and more you're going to see hubs and spokes of private dispute resolution in many areas, and starting again with the international arena and the internet arena. I think are going to be driving forces in that area. But I think you're going to see it more and more in many walks of life, in the insurance industry, in the workplace, more and more. And I think a lot of the driving force is going to be in the organizational level. And by organization, I mean everything from corporations to associations, universities, hospitals, gated communities, business-to-business trading trading networks. All kinds of organizational structures are going to be looking at creating their own dispute resolution programs, and then I think what you're going to see is a lot of networking between those programs. That's what I hope for, and I'm optimistic that that's going to be the trend, and you're going to see less and less of sort of civil dispute resolution taking place in the courts.
Arthur Pearlstein, thank you very much on behalf of Mediate.com. It's been a pleasure. Good.